Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors legal hotline lawyer. This is the first in a 3-part debrief series that's going to introduce a Friday video series. And this is a video series that I am extremely excited to bring to you. It's fun for me to work with these two people who you probably don't know. I'm going to tell you who they are in a minute. But I'm also excited for you because you are getting to hear from the ultimate source regarding audit issues and license law issues, the WAC requirements supporting license law issues from these two individuals. Bill Dutra, Cathy McDonald. Bill, who are you?
So I work with the Department of Licensing, the Business and Professions Division. One of the great things that I get to do, besides support 38 different professions, is meet with our licensing partners, Washington Realtors, Northwest Multiple Listing Service, to name a few. That's what I do for the department now. I've been there for just over 30 years, and I spent the majority of my time working with the real estate professions.
I will tell you that as a hotline lawyer, if I have a question that I can't answer with regard to license law or the WACs that support license law, my final stop for answers is Bill. One of my preliminary stops might be Cathy McDonald. Cathy, who are you?
I am the Audit Supervisor for the real estate program. I have 9 auditors that I supervise. I've worked with the department in the audit unit for over 16 years. And it's my pleasure and my staff's pleasure, actually, to get to work with the licensees. My auditors love their jobs. They like engaging with the licensees and helping them come into compliance. So that's what we do.
And so the title of this video series and the Friday video series that we're introducing as well is called Thriving Through an Audit. We want to empower you as designated brokers to have the tools that you need to believe that you will be equipped the next time an auditor shows up in your office, or I guess online now, electronically, they show up in your office more.
Yes,
often
currently
than not.
remotely.
Yeah. That you will be prepared to thrive through that audit. So in this debrief episode, we're going to cover the question of delegation agreements. And then in 2 additional debrief episodes, we will cover proper folder management and required office policies. We are also going to bring to you, the 3 of us, bring to you educational tools that you can use with working with the brokers in your office in the form of Friday videos, talking about compliance issues that pertain directly to your brokers and to you as well, but specifically to your brokers. So in this episode, let's discuss delegation agreements. Who wants to describe what is a delegation agreement?
So I'll start. A delegation agreement is an agreement between the firm, the designated broker, and a managing broker licensed to your firm. The delegation agreement allows that managing broker to have some duties and responsibilities in place of the designated broker. However, something to remember is that this does not eliminate ultimately the designated broker's responsibilities to that firm and to that licensing law. This is just adding another person there that can help the designated broker run the firm. They're very common with really large firms or with people that work in cooperatives within those firms, that there's a group of licensees working together. There are many times where a delegation agreement will come in handy and is required.
Okay, let's pick up in a minute on when it is required. But I want to give everybody a quotable quote that I learned from Bill long ago, and this just summarizes so perfectly what he just said. Annie, here's what I can tell you about a delegation agreement. A delegation agreement can delegate authority. It cannot delegate responsibility. So while a designated broker can give authority to a managing broker to provide certain services, to fulfill certain duties that the designated broker is required to fulfill, the designated broker can never shield themselves from responsibility or even liability by using a delegation agreement. Cathy, there are some specific requirements of a delegation agreement. Can you talk about what those are?
From an audit perspective, when we look at the delegation agreement, we expect it to be signed by the designated broker and the managing broker that the duties are being delegated to. We look for that during the course of an audit to make sure that exists. We don't necessarily scrutinize the content of the delegation agreement. That is something that would more come about like if there was a complaint during an investigation to see what type of duties had been delegated, and if possibly there's supervision. And within the complaint, there's something in there that shows that, okay, who was responsible for the supervision of this licensee? Who is reviewing the contracts for this licensee at this time when this complaint was made? So then the content of that delegation agreement would become much more important at that time, due to the fact that we might need to see, okay, not only is the designated broker still responsible, but what kind of responsibility does this managing broker have in regard to this complaint?
Okay. So what I heard you just say, correct me if I'm wrong, is that you might be doing an audit, you might be reviewing a folder, transaction folder that was put together by a broker who's been licensed less than 2 years, and maybe that folder indicates that Mary Smith, not the designated broker, but a broker named Mary Smith has reviewed that broker's work. What I just heard you say is that your auditor is going to look for a delegation agreement where the designated broker has delegated the authority to review that broker who's been licensed less than 2 years work, that the authority to review that work has been delegated to Mary Smith.
Correct.
Right?
Yeah.
And what I heard you also say is, so long as that delegation agreement is in place, even if it's not sophisticatedly drafted, as long as it's there, the auditing department is satisfied.
Right. We don't dictate that it has to be prepared by an attorney. If it's their own document, we don't look at it from that perspective.
But what I also heard you say is that if somehow or another that transaction finds its way to be the subject of a complaint or even litigation, then the actual form, the content, the language used in that delegation agreement could be scrutinized by lawyers, by judges, by an administrative law judge. And so it may turn out that having those delegation agreements drafted by legal counsel could be important in some circumstances.
Yeah, for sure.
So designated brokers, you and your managing brokers can create delegation agreements that will enable your managing brokers to provide certain duties that you would have otherwise owed to your brokers. Whether or not that delegation agreement is competent to withstand the scrutiny of litigation or a complaint that might be filed against you or your firm, that's a question that can only be answered in hindsight, which means that you may want to, at the front end of things, hire legal counsel, ask your firm's lawyer to assist you in drafting delegation agreements. You're not required to. Cathy doesn't say if it's not drafted by a lawyer, then you're out of compliance. She's not going to say that. But if push comes to shove and you have to stand on that delegation agreement, then it might matter how it's drafted. Bill, you said a few minutes ago that the delegation agreement is required when a designated broker has another broker, managing broker, take on certain duties for the designated broker. Did I summarize that correctly?
Yes.
So can you give any examples of that? Can you explain to us what you mean by that?
So if using your example, if you have a managing broker that is reviewing the agreements for the firm, especially for brokers under heightened supervision, then you need to delegate those authorities and that responsibility to a managing broker. That would be one example that would use. Having a delegation agreement, again, allows that designated broker to give some of those duties to a managing broker to deal with very difficult situations, releasing a listing of all things. If there's a problem with a customer, a managing broker can do that. They can't do that unless there's that delegation in place between the firm and the designated broker and that managing broker.
So you just made me think of something. And I will say that Bill and Cathy have taught me something today about the use of delegation agreements. I think that I would have said on the hotline that you did not have to have a delegation agreement in as many circumstances as Bill and Cathy think it would be important. But here's what I have learned from them as they've spoken is that delegation agreements, while they might be required under the law when you've assigned duties to somebody else, I'm also hearing that they provide a layer of protection to designated brokers and the firm by making it very clear in writing who is supposed to be doing certain actions within the firm. Because if there's no delegation agreement, then designated brokers, and even when there is a delegation agreement, but if there's no delegation agreement, you clearly have every single responsibility under Washington's license law, the minimum duties under the agency law, and all of the WACs that support those pieces of legislation. But if you have delegated authority to another broker and that broker's or the fulfillment of those duties comes under scrutiny through a complaint, litigation, then the fact that you have delegated that authority to somebody else, if you can show that in writing, that could be very important to the protection of you and your firm. Is that a fair summary?
I think it's a fair summary because when we receive complaints and we look at things, before we make a decision that we're going to take action against someone's license, we look at all of the aggravating and mitigating factors of what happened. I would also mention is that real estate has changed in the last 10 years. It's changed in the last 5 years with the way that firms are set up and the way that people are working. We have people that their licensed firm is in Seattle, but they've set up shop in Spokane. They're working in Spokane. And if you have brokers on the other side of the state, I know with technology, we all talk with each other via Zoom, probably too much now. But I think this is a great opportunity for designated brokers to have a good look at what's going on in their firms, have those conversations. This allows them to set expectations, set requirements of who's responsible for what and when. And if that makes most sense for that designated broker to give some of those responsibilities to somebody who's a managing broker who's working in Spokane, who's licensed in Seattle, I think that's a great time to have those conversations and put in there what it is that you need them to do to make their job easier and to make your clients' jobs easier.
And to make it really clear what that direction has been.
Yes.
So, okay, I think that's probably worth gold right there. Designated brokers, be forward looking in what is happening within your firm. If your firm is isolated to one single physical location, great. If it's spread out all over the state, great. No rules about what that should look like, but you are responsible for everything that's happening, whatever your firm structure might be. And so what Bill just said is designated brokers take control of this issue and be forward-looking now to see what is actually happening within your firm structure. And to the extent a delegation agreement would not only clarify the role that managing brokers are playing, but even potentially protect you as the designated broker in an audit or an investigation scenario, get those delegation agreements in place now. One thing we haven't talked about yet, how does a delegation agreement play into branch management? What's the relationship there?
So basically the expectation is the same. So as far as a branch manager, they have certain responsibilities that are delegated just by them accepting that position and taking that designation because it's an actual licensure process, right? But in addition to that, there may be other things that the delegation agreement may include with that branch manager. So it isn't just the things that happen by license law. It can also be other things that may be delegated. And we have the same expectation during an audit that will be signed by the designated broker and the branch manager. We do run across that commonly, that they don't realize they need them for branch managers, but it's required no matter what, whether it's a branch manager and a designated broker or whether it's a managing broker that's just delegated specific duties or specific activities for that firm or branch.
Okay. Anything else on this topic?
No.
If you have questions on anything we've talked about in this episode, send me a question, warealtor.org, following the links to the legal hotline. I may need backup on the questions that you've asked, and if so, I'm coming back to you guys for that. Stay tuned, though, for 2 more episodes in the DBrief series where we're going to bring information specifically to you, designated brokers, and then the Friday video series entitled Thriving Through an Audit. Thank you for being a Washington Realtors member.